In this episode, we're going to do a deep dive into the due diligence you need to do when buying a strata or community title property. There is a lot to unpack, and we have a special guest expert to help us out.
Welcome to Your First Home Buyer Guide, the podcast for first home buyers who want to get it right.
I'm Megan, and that was Veronica. We're both buyers agents and probably old enough to be your mums. But that's a good thing because between us, we've got over 40 years experience, and we are going to share with you bucket loads of stories about avoidable mistakes. Together, we're going to make sure that you get unbiased and real information that you can rely on so you can get where you want to be without missing a step.
Now, we've got loads of great tips for you in this episode, and if you'd like more useful tools, head over to the website homebuyeracademy.com.au. There you'll find free checklists that you can download, a free mini course on how to price a property, and our Where to Buy workshop for only $39. Priceless stuff, really.
Bargain. But before we get into the interesting stuff in this week's episode, here's the boring bit, the disclaimer. You, of course, know that nothing in this podcast is to be taken as personal advice. We always recommend getting the advice of an expert in their field of expertise. Now, we've done our very best to ensure that the content is correct at the time of recording, but things change. So check with the relevant government authority or your advisors to get the most up-to-date information.
Today, we're talking about the importance of knowing exactly what you're buying into when you buy an apartment, townhouse or villa. We're joined by Dr. Nicole Johnston, who is a senior lecturer and researcher at Deakin University's Faculty of Business and Law, where she specialises in property law and socio-legal strata research. She is considered an international expert in strata, and we're honoured to have her speak with us today. Welcome, Nicole.
Welcome.
Thanks very much for having me.
Oh my goodness, it's so impressive. I just need to pick myself up off the floor. Nicole, one of my favourite sayings is that we don't know what we don't know. And that's really the basis of, what we're trying to help people with at the moment. And that's possibly never more true than when buying a multi-owned property. What? I hear some of our listeners say, it's when you buy a unit or an apartment or a townhouse or a villa or anything that's not freehold, you're actually part of a group of owners. Now, it's not a bad thing, and it can be a really good decision if it's right for you, but like everything in property, it comes with risks. So let's open up the backpack and unpack this whole thing together. Nicole, can you start by briefly explaining what we are doing when we buy into a property that is not on an individual title?
Yes, so it's very different. I mean, you are getting an individual title, but you're getting more than that. And so I think that's where the confusion can be about what you're actually buying. And so for most people, I think they're just looking for their little, part of paradise, their little home, the thing that as soon as you open the door and you open and you go into something that's what you're actually buying, your apartment or your villa or your townhouse. But you're actually in a co-ownership structure as well. So even though you are a fee simple freehold title, hold that title to your actual apartment, you are also in a co-ownership environment. So that means that there are rights and responsibilities that go with that purchase because you, with your other lot owners, so everyone else that owns an apartment or a villa within your development, also owns a part in that common property area. So depending on the state or territory that you actually reside in, this is where it starts to get really confusing about what common property actually means, and it's very different in every single state and territory, of course. Nothing's simple in this country. So you've got to know exactly what that means. What is the common property in that development? So it could be the actual external infrastructure, so everything that sort of sits outside of your apartment, and where the boundary line is between you and your neighbouring lot is very different depending on each state and territory as well. So there are lines or boundaries that are drawn around that particular building or around that particular development that lets owners know what they own and what is commonly shared in that collective ownership structure. So it does get really, really confusing. So there's not a sort of a simple way to say what you own and what you don't own. It really depends on where you're actually purchasing that particular property. But getting down to sort of the fundamental basics. So you're buying a part of, the hallways, the lift, the building, the gardens, the pool, the gym, whatever infrastructure sits within that development, you own a little slice of that particular common property. And so that's from a sort of what you actually own. But then there's the next part of it, which is about the fact that you have responsibility being part of that collective ownership through an entity called the body corporate or the owners corporation. So it's a very, very different environment legally from a freestanding home that we're very probably used to growing up in Australia.
I'm curious if maybe you can help us here. Why do we have different legislation in different states and territories when it comes to property?
Yes, so that is the really frustrating thing for all of us that either buy property in different states or work in different states and that sort of stuff. It's very confusing, but it just comes back to our federal system and the way that the Constitution has been formed. So as we know that there are some things that the federal government has responsibility of, they make legislation in relation to certain matters, and then everything else is reserved to the states. And so property generally, so lots of property laws, including strata or owners corporation laws, are then reserved powers to the states and territories. So it's up to each state and territory to regulate this property type. And so what we have always hoped would that there would be some sort of consensus or mirroring, I suppose, of the legislation across the states to make it easier for everyone. But it just seems that over time, the legislation that regulates this area is getting more complex. It's getting much more dense. There's more laws and regulation than there ever has been before in this area. And each state's gone about it in a very different way. Fundamentally, there's some core things that are very similar. So we know that the legislation that regulates these property types is essentially like a governing sort of framework. So it tells owners and it tells the owners corporation or the body corporate what it can and can't do, how it holds meetings. It gives it sort of a guide. It's basically a guide embedded in the legislation telling people in this sort of property arrangement what they need to do and what their responsibilities and the liabilities that might arise in relation to being part of this property type. And so, unfortunately, everyone's sort of gone off on their own tangent and changed the legislation in different ways. But fundamentally, there's that sort of core area that it's a guidance for owners, corporations and bodies corporates about how to govern their scheme. And that's what the collective ownership group needs to do, and that's what they need to understand. They're governors. That's the whole point, that they're there to govern their entity, their private governing entity, which is the owners corporation or the body corporate.
Veronica calls it the fourth level of government.
Yeah, and it really
is. It kind of like
when
that?
You start to get down. Yeah, when you get down to the nuts and bolts, it's a little bit like company law, and it's also a little bit like a government structure. It's sort of like the combination of both of those things. So when you think about it, we've got the federal government, we have state and territory governments, you have local governments. Then the fourth tier, as Veronica has said, is this other type of group called the owners corporations and the bodies corporate, and they work very much like that. They're there to govern that development or the scheme that they're in. But it's a little bit like how a normal local government works. They've got bylaws or rules that regulate behaviour and those sorts of things. But it's also a little bit like a company. So it's sort of a bit of an amalgamation of those sort of two structures, if you like, is what we sort of see. So it is really complicated, I must say, and for owners that are new to this, it's a real minefield, and it's unfortunately something that you have to step into because you are automatically a member of the body corporate when you buy into an apartment or a villa or a townhouse. You can't get out of it. There's no, escape route for you. You must be part of it. How active you are in the decision making is really up to you, but someone has to put up their hands and be an active member in the body corporate or the owner's corporation. So it's really up to each individual lot owner how actively they're involved in the owner's corporation or the body corporate. You can be on a committee if you want to be. I mean, someone in the development has to put up their hand to be that person on the committee, or a group of people that have to be on the committee. But if you choose not to be so active, if you choose not to be heavily involved in the owner's corporation or the body corporate, you still must be aware of what's going on, because there are legal obligations and there are responsibilities that flow just because you are a member of the owner's corporation or the body corporate. And that's the really difficult thing for people to understand. And that's the area that, regardless of how much you want to be involved, you must understand what's going on in that development because of the legal liability that flows to you as a lot owner.
This is great stuff. So a few episodes back, we had Amanda Farmer, who's a strata lawyer. She came in and took us through the steps to inspect records before you buy into a strata or community title property, right? And we were sort of approaching it as to more about the quality of the building, the way it's run, whether there's defects and those sort of things that you're looking for. But the other aspect to that is that you do have obligations when you're buying into a building. And like you just talked about, the legal obligations. So, one of the reasons I want to talk to you is to really look into the due diligence from that aspect, to say, what else do you need to be on the lookout for when you are buying into one of these buildings?
Yeah, so I think it's really great that you've had Amanda on, and it's really important to understand what types of records are available and what rights purchasers have and owners have in relation to inspecting the records. And it's something that should really be undertaken when you're deciding to purchase into one of these properties, as I'm sure Amanda made your audience very aware, and what they need to look at and who they can engage to read these documents and interpret them and provide good, sensible assistance and feedback to their clients. And so it is really, really important. I think what you've got to be aware of is there's lots of different tricky bits within a strata scheme, and when in terms of liability and responsibility, and liability in particular is probably the main thing, because of the collective ownership and because you are dealing with sometimes a very large scheme that costs a lot of money to run. You need to make sure that financially that has been working really well, that correct decisions have been made, and so that there's not going to be a time that will come where you will be asked to throw more money in the pot, so more additional levies, for example, a special levy may be raised, to deal with issues that may arise that there is not enough money in the account for that particular expenditure. So things come up all the time. You may get, if there's a storm, you may get storm damage, and while you're waiting on perhaps insurance, or insurance might not cover a certain thing because of the type of exclusions within the policy or something like that. It'll be up to the collective ownership to make sure that the building is maintained and repaired based on whatever's happened. And so if there's not enough money in the account to pay for those perhaps repairs, then you will have to, and it's something, again, you can't just avoid. And even if you may vote no to having a special levy raised for that particular purpose, if it's the collective will, then you will be required to pay a certain amount for those repairs, for that maintenance, and what have you. And it may be that, things may crop up where there's not enough insurance, the insurance is not appropriate for the scheme. And if there is an issue that comes up where there's a liability issue that arises, again, you will be required to put your own money into the body corporate or the owner's corporation account for whatever damage that has occurred in that particular site. So you need to be aware how that scheme has been functioning, whether it's a dysfunctional scheme, whether proper decisions have been made, and those sorts of things, because ultimately there's no protections, there's no liability protections afforded to lot owners like it may be if you're a shareholder in a company. Those protections are not afforded to you in strata. And so if there's a liability that arises, unfortunately, you are going to have to come up with the money, whether you have it or not, to pay for whatever that deficit may be. So you need to make sure that you're very aware about what's going on and how the decisions are being made, so that you are not stuck at the end of the day with a large bill that you never saw coming. And again, you'll be forced to pay it. So you really need to be actively aware of what's going on, not only when you're wanting to purchase, but throughout the ownership of that particular property. You need to be invested somewhat in who's making decisions and how those decisions are being made. Strata is an expensive product to buy. It doesn't matter that, the purchase price might be relatively cheap compared to a house. There are ongoing maintenance costs, ongoing insurance costs. There's so many things that you have to pay into Strata that is very, very different from when you are home. And so there's those sort of financial responsibilities are ongoing, and you need to be very aware of that when you're deciding to purchase into Strata.
That's such good advice, because it's a lot of things you need to think about. And it raises so many questions in my mind, because I've never purchased Strata for people. I've never owned Strata. So I haven't been a member of a body corporate or a owners corporation. What are some of the other things that people need to think about when they're co-owning with other people, like body corporate meetings and how you live with other people and bylaws and those sorts of things? What are some of those other things they need to think about?
Yeah, it can be really tricky, and it's certainly not for everyone. If you're a really sensitive person in terms of noise, food smells, pets, all those sorts of things. If you are super sensitive when it comes to all that sort of thing, Strata may not be you, or it may be that you need to be in a very small type of scheme, or a particular type of scheme in a particular type of area. The larger schemes may really not be for you, because depending on how the building's been built and the age of the building, you might get a lot of noise that sort of is referred from somewhere else. You can get some echoing sometimes. You may get different smells from people cooking different things in a building. There are some schemes that are really pet friendly, that are very open for people to have pets in the building. Some are very anti it, and we've seen a number of cases and a number of issues raised in relation to pets. And so understanding what the collective rules are, so what people have come together to say, this is the rules that we want for our particular scheme, is really important, because if you're someone who wants to have pets around and you want to have your dogs or cats there, you need to find a scheme that's really amenable to that, that's really open to having animals, and they've got really good rules in dealing with sort of issues that, constantly come up with pets around noise and those sorts of things. If you're very anti that, well, again,
you want to find the
stay
opposite.
away. Yeah, stay away. So, there are a lot of people don't work well with Strata that are very sensitive, but a lot of people do. You get really used to it if you're sort of one of those people that, can go with the flow a little bit. You get really used to the noises and those sorts of things in Strata. And Strata can be a great place to be. There's some fantastic communities, and you can feel sort of safe and secure in those sorts of apartments. So there's some really great things about there's really great developments and some really great schemes out there that you want to be part of. But again, it comes back to your due diligence. You need to know what is actually going on. You need to speak to people that are part of that development, if it's an existing development, to find out how it works. If there is a good functioning committee, for example, who's been on the committee, do they make really good decisions? Is there a lot of conflict at the committee level? Is there a lot of conflict generally in terms of the scheme? Is it, is there good, harmony within the development? All those things are really important from just a livability perspective, that you feel at peace there, that you feel safe and secure. You're not, overly disturbed. There's no nuisances and those sorts of things. So there's those sorts of livability factors that you have to look at. And then, of course, then as we've spoken about, there's the responsibility part of it that, yes, you will be getting levies. You need to pay every quarterly a certain amount of money to the owner's corporation. You will be getting AGM notices or meeting notices to attend and to vote in relation to particular decisions that must be made in relation to the functioning of your owner's corporation or body corporate. And so there is a lot more to it, but it can be really good, and people shouldn't be afraid of it. It's just like anything new. When you haven't been part of it before, it just takes a while to adapt. But I think the point here is you need to do some investigation before you get yourself into a particular scheme. Every scheme is different. You might the one might be fantastic, really well run, really well managed, and got good, financial statements that can be shown. The building next door that could look exactly the same could have none of that, could be dysfunctional. People mightn't be getting along. There might be a lot of conflict. There might be litigation issues. So you need to really undertake some investigation, do that due diligence before you get part of it, because it can go either way. It can be hell, or it can be a really fantastic environment where you feel really safe and secure.
It's a classic. Back in November, a story hit the headlines around a massive conflict in a Strata meeting, which was held in a basement. I don't know if that's got anything to do with it. You're nodding vehemently, Nicole. What happened with that? It hit the newspapers. Massive brawl.
Yeah. So, I mean, this is probably, in relation to a building that's had some real issues. So, has had a lot of attention around some massive defect issues. And so I do actually feel for the people there, because they've been put in a position originally not from their own doing. And so they're just now trying to work out what's the best way forward. And if you are part of a building like that has major structural defect issues or other massive big issues that you're trying to deal with, that's impacting your family life, your financial stability, everything about the way that you live is being impacted because of this one issue. It's not surprising to me that we're starting to see this sort of thing. I think there's obviously some issues around management. I believe that there were sort of two groups in relation to the way forward in relation to dealing with some of the issues in their building. And so I think there's just been a build-up of over a number of probably months over the last few years that has sort of led to this, whether that's part of a bit of poor management, people really not understanding the complexity of the situation and that sort of thing. So I think that probably stands out as a particular type of scheme that has got a lot of problems and they've got a huge mess to sort out. It's not the usual, I don't think, in Strata. It's really the exception to the rule. But this is what can happen, unfortunately. And, there's international cases around where, there's been lots of argy-bargy and all that sort of stuff. Of course, it depends on the approach. Again, that's a bit of a difficult one because that's just, I think, take that as a standalone case that has happened. I think
lessons to learn, though, isn't there, Nicole? Like there are some little bits and pieces about questions to ask, maybe.
Absolutely. And so if you're going into a building, you absolutely need to understand what's going on in terms of sort of the building defects, how, who's in charge in terms of who's on the committee, how the committee works. All these fundamental things need to be answered. What are the qualifications of the people on the committee? Not that there's a requirement to have certain qualification, but you want to know that the people that are on those committees have either undertaken some sort of education or training to understand what their obligations are as being part of that committee, that they're working very well collectively, that they're working in the best interests of all the owners collectively, that there's not a lot of conflict of interest or selfish decision making being undertaken. And you can usually find that out by just doing a thorough inspection of the records. You can find out very quickly how that committee actually works. And if it's a really well-functioning committee, if they're making really sensible decisions, sometimes they have to make really hard decisions, but they're in the best interest of the people, the collective ownership. Well, that's what you really want. If you start to look through the minutes of meetings and those sorts of things, and you're starting to see a lot of disharmony, a lot of conflict, a lot of argument, which you can sometimes see in minutes or in other correspondence, or you go and speak to people, speak to the manager, speak to people that are on the committee. If you start to get a sense that there's quite a bit of conflict, that's something that you want to avoid. And so there are those sorts of lessons to be learned, and we've seen that in sort of what's come out in the news in relation to that building, that, it's very fractured. Obviously communication is broken down terribly, and, it's going to be a very difficult hill, I think, for those people to climb to reach any real resolution in relation to what's going on with that building. And so, it always comes back to know what's going on in those buildings before you get yourself involved.
Absolutely. And I think what's interesting too, and I interviewed you a couple of times on the Elephant in the Room, and recently we did an interview around the due diligence and the gatekeepers, who's blocking information. And one of the things that was so if anyone's interested in wanting to know more about this, then go to the Elephant in the Room and listen to that. But one of the things that I thought was really fascinating is that, Megan and I talk about this all the time about the contract of sale. And we're mostly talking about houses, but we talk about in Queensland, the level of disclosure for vendors is almost nothing. Mm-hmm. In Victoria and New South Wales, it's fairly high, but even then it's not enough. So there's all this stuff you don't know. And as we say, you don't know what you don't know. And if you don't know that you don't know it, you're not going to go and find it out. You could buy houses without half the things, without knowing half the things you need to know. Weirdly enough, with Strata or with community title, it doesn't follow the same pattern. I mean, Queensland has got a higher level of disclosure than in New South Wales, for instance. So I know, and in Victoria, you've got a Section 32 certificate, and in that is the Owners Corporation, what's that called? The Owners Corporation certificate. And so I think a lot of buyers rely on, when there's states where there's a prescribed amount of documentation you're meant to be given by the owner or by the agent, a lot of buyers just rely on that, thinking that's enough, but it isn't necessarily. So do you want to sort of touch on what else buyers need to be looking at?
Yeah, and so this is, again, a difficulty, especially when you're moving from state to state and you're buying into Strata, no matter where you are, because it is very, very different. Queensland goes almost over the top in relation to disclosure, but only for off-the-plan sales.
Yes.
So when you're buying something that's not existing, so if you're buying off the plan, something new is coming out of the ground, the disclosure regime is very, very comprehensive, to the point where we think that probably not a lot of people are reading it. But it is useful, because if you've got a really good property lawyer, or if you've got a really good conveyancer that knows really what to look out for, that know the warning signs in relation to the disclosed information, then that's a good thing. In terms of existing property, it's completely different. You get very little information in the contract of sale in terms of what's going on with that. And so it really does force someone to actually go and do an inspection of the records to find out the nitty-gritty and what's actually going on with the building. Disclosure does serve a purpose, no matter how much there actually is. But what you really want to do is you want to verify that the information that's being provided in those contracts or those disclosure statements are up to date and accurate. And the only way that you can do that is doing an inspection of the records. And we have seen in research that we've done that sometimes that information is disclosed, whether it's in Victoria with an Owners Corporation certificate that's attached to a 32 statement, or in any other jurisdiction. Sometimes it might be information that's provided at a particular point of time, and that information has changed. So when you're given that statement, for example, in Victoria, between then and actually purchasing, things may have changed. And so you need to go and verify the information that's correct. You may be provided some information that, this is how much money is in the sinking fund, and that, you're under the maybe perhaps mistaken belief that there are no big maintenance or repair issues pending. And then by the time you get to actually sign the contract, there might have been a period of time that has lapsed, and things may have changed. All the money might have pretty much gone from the sinking fund or the capital works fund, because they've had to, pay for a new roof, or, a number of a meeting could have been held if special levies or the annual levies may have been raised quite significantly that then would impact upon your decision to purchase. And so you've just got to be really careful in that period of time and what disclosure actually means, because there may be some inaccuracies. And so it's back on you as the purchaser to make sure that you go and investigate to see whether that information is actually accurate, what has changed in that intervening period, and whether that information can be verified by looking at the records. So a little bit of care needs to be taken in relation to that.
Can we rely on our lawyer or conveyancer to check those records?
It depends on the state sometimes that you're in. So Queensland and New South Wales have for quite a long time, most good conveyancers and property lawyers would advise their clients to get an independent search agent to go in and do an inspection of the records. These are people or companies that do these sorts of inspections quite regularly. And then you can choose if you want to go back, 2 years into the records, or you might want to go back 6 years and have much more of a comprehensive review of the records to see what's been going on over time. And so that's been quite customary practice in New South Wales and Queensland for a number of years. And then it's really on the purchaser to make that decision. So in Victoria, it's a very different situation. So in Victoria, they've never really had many companies up until very, very recently that you can go and get an inspection undertaken from that sort of independent party who knows what to look for in the records and provide that report back to their conveyancer or lawyer on the purchaser's behalf. And so it's been quite different. There's been a much more heavy reliance in Victoria on those owners' corporation certificates. And of course, if you're buying off the plan in Victoria, the information that's provided to you is negligible. There's hardly any information that's actually provided to you about what you're getting yourself into. And so the due diligence around what happens in Victoria in relation to off the plan is very different. You're going to have to go or get your lawyer to do different types of investigations to find out who the developer is, who the builder is, maybe what their past reputation in relation to the creation of these types of schemes may be. There's a lot of information that's really missing in relation to Victoria, and that certainly needs to be improved. And so, it depends on the state. So in terms of your lawyer, what you need to look for is either a lawyer or a conveyancer who really does understand what goes on in strata schemes, what are the issues that might arise that you can find by looking at the records and that you can extract. So what I've found in the past is there are a lot of conveyancers that will just take the information from the contract or the disclosure statement that's been provided and just really rehash it to the client. This is what it's saying. They're not really doing that sort of further deep dive into the records to see really where the pitfalls are or what are areas of potential concern that may need further investigation, or that that awareness might need to be brought to the purchaser's mind when they're making those sorts of decisions. And so you really do need to find, and you need to spend some time finding a property lawyer or a conveyancer who really, really understands strata very, very well, understands what can occur in relation to strata, and it may be in a firm that may have a litigation specialist that deals with strata who has a much better understanding about what's going on, because they're seeing the pitfalls and what can actually arise in relation to litigation all the time, and so what people might need to look at from the front end. So I would say before you even think about purchasing a property of this type, you really need to go and find a lawyer or a conveyancer that knows this stuff really well. And they're the people that you need to be engaging with. This is not an area where you find the cut price conveyancer that charges you
exactly
$400 or
the same
$500.
thing. You took it out of my mouth.
Yeah,
it's not where you cut costs, right?
Not where you cut costs, because the danger is too great, right?
Yeah.
The risk is too great for most people, unless you've got heaps of money in the bank and you don't care what happens, which is not the majority of people, then you need to be very careful up front, and you need to make sure that you invest in a really good lawyer who is going to look at that. So many conveyances are very just transactional based. It's about transferring the property from the seller's name to the new buyer. They're going through the process, and that's why it's so cheap. They're not giving you actual advice about what's going on internally within your scheme. they're not telling you where the boundaries are and what you actually do own and what you don't own and where your co-ownership actually sits. They aren't looking at the lot entitlements and liabilities to see whether they're fair. They're not looking to see whether your levies are probably going to go up. They're not looking at the defects. They're not looking at the maintenance issues and what potential outcomes there might be for you. So you need to find someone that really understands that stuff really well. That's where your investment has to go, as well as, what you're actually buying. You can't skim. I think it's a big risk to skim at that stage. And so my advice would be, before, when you're starting to think about purchasing strata, spend some time finding someone who's really good in the area that can really not only do the transaction, but actually give you proper advice about what you're purchasing.
100%. And,
Gold.
And a lot of due diligence is looked upon by buyers as just being tick boxes. And I think the choice of a conveyancer or a lawyer sometimes fulfills that sort of ticking boxing type approach. But we talk about in your First Home Buyer Guide course, the very first step is getting the right people on your team. And absolutely we are 100% on board with getting an experienced conveyancer, not a cut price one, or a property specialist. And in different states, they're called different things. In New South Wales, accredited property specialist. But somebody, and then beyond that, they could do a lot of houses, but if they don't do a lot of strata, then they're going to be out of depth. What sort of legislation, though, is in place? Is there any legislation in place to protect, property buyers in this scenario?
Well, there's always some protections that are afforded to you in terms of the information that is provided to you. So if there's inaccuracies in relation to the information that's being disclosed and those sort of things, there's protections. But there's not protections when it comes to probably a bit of stupidity or not, taking those extra steps. So, if the information that is disclosed to you in accordance with the legislation is accurate, and then you find out something later because you haven't actually inspected the records. Well, unfortunately, that's going to be on you unless it's quite a material issue. It does come back to the purchaser to actually undertake their own due diligence to find out what exactly that they're purchasing. They need to protect themselves, and they need to do that by those sorts of mechanisms that we talked about, getting a really good lawyer, investing some money into getting the proper person to assist you, asking the right questions, getting someone to make sure that they're doing a thorough inspection of the record so that you really know what's going on, verifying the information that's been disclosed already in the information provided to you in your contracts and those sorts of things. You have to and go to the scheme, have a walk around, talk to the people, get a feel about what's going on in the development. All those things are really critical, and things that you really need to do as part of, your due diligence.
Spot on.
So many pieces of gold in that. Honestly, I've never bought in strata or community title as it is in Queensland, but I know, Veronica, you have. I'm going to ask you a question in a moment. But Nicole, we always ask our guests, what is the one thing you know now that you wish you'd known as a first home buyer?
I think the thing reflecting, and there are quite a few things now that I've been researching in this area for a long time, and I think back, and my first little property that I bought was off the plan in Queensland. I think I would have investigated more thoroughly the developer and the builder, who it was that is creating the vision, what their past experience was. Go to the sites that they've worked on before. If it's residential construction, have a walk around, speak to people, because oftentimes I've found is if they stuff up, the last development or the development before that, past behaviour dictates future behaviour, right? It's more likely that, that lessons may not have been learned. And so I would always, that's what I think I reflect on the most, there's some things that people do that you can never see coming, no matter how much due diligence you do. But I think, going back and speaking to people in other developments of those same developers and those same builders to find out their experiences, have they had issues with defects, walk around, talk to the people, get a sense of how, they're feeling about the development, how the transition period was from when the developer was involved to when they left the scheme. For a new scheme, sometimes can be a really long period of time, and any flow-on effects in relation to the decisions that were made by the developer on behalf of the body corporate or the owners corporation, just to get a sense of what's gone on. And I think people are usually quite happy to chat, especially when things have gone really wrong in their development and they've got regret. And so when people walk around to say, how do you like it here? Have you got any issues? And they go, oh my God, so many issues. Red flag, people, red flag. Find another apartment.
That's it. There's always another one. I'm going to add to that when when it's a new building or a off the plan, then it's obvious who the developer is, it's obvious who the builder is, right? That's sort of everywhere. But when it's only a few years old, it's not so obvious. And if you can't get that information, is just as important on a building that's sort of probably even 20 years old, given some what's happened to some buildings. If you can't get that information, then give it a wide berth, I'd say, because often you can't get it after the building's a few years old.
Yeah, I think when there's holes, so when there's gaps in information, when you're asking questions and you're not getting any answers, or there's an inability to find out what's going on, the risk, I think, escalates. And so you do have to be so much more careful. And I think sometimes, though, with existing buildings, it doesn't probably matter how old they are, as long as they're a few years into their life, you get a sense of the quality of construction fairly early on. And if you're in, because water, as we know, water ingress, water-related defects is probably the number one defect issue in all new builds in this country, and has been for a number of years. And so water manifests, or water ingress or water-related defects manifest really quickly in a building, because as soon as you have your first rain event, you know where the water is leaking and how problematic those particular defects are. And so again, you talk to the people, had any leaks? That's what I'd be asking in a new development, or a relatively new development, anything that's sort of less than 10 years old. I'd be walking around saying, have you had any leaks here, any issues with water coming in? And if there is, again, be careful.
I'll tell you. Yeah.
They will tell you. They will tell you. Yeah.
100%.
Oh, look, personally, I've mentioned I've only ever owned freehold properties, but Veronica, you've been knee deep in the industry for over 20 years and you've learnt a lot. Your first home was a strata property. For those who tune in regularly, you'll know it's a tough ask, but in 1 minute, what is the one thing you've learnt since you purchased your first strata title apartment in, was it 1996,
I think it was. And it was also off the plan, although it was built. So it was off the plan technically. But
1 minute.
1 minute. I guess the one thing I would say is that history, because I own two strata properties, two, and I've been on the committee both times. So the one thing I would say is, if you ever, I think it's worthwhile getting on the committee just to understand the building and how it runs. And even though I've only owned one of those properties now, but I'm no longer on the committee, but I do get how it runs. And I do understand the building in a lot more, because you are buying into more than just your apartment. So I would say it's a bit of an obligation. It's a bit of a pain in the ass at times, but it's certainly worthwhile doing. Right. Well, Nicole, I really appreciate you coming on. We both really appreciate it. And when I say it's because I've chewed her, or I've asked her to come and tell us all this stuff, both on the elephant.
I've learned a lot.
Good.
It's been fantastic, and I really appreciate you stepping that out. She's a wealth of knowledge and very generous, given that you spent all your time researching, to actually come and share some of those findings with us. So really appreciate your time.
Very
pleasure.
grateful.
Thanks very much for having me.
In this episode, we've covered a very small part of our 10-step online course for first-time buyers. If you would like to learn more about the process and how to buy without making a mistake, then head over to our website, www.homebuyeracademy.com.au. Don't forget to subscribe to the podcast so you won't miss an episode. And if you like what you've heard today, please give us an iTunes review. 5 stars would be wonderful. It will help others find us as well.
Thank you for joining us. We hope you found this really useful. And if you have, please share the love with others who you know are in the same boat. We'll be back next week with some more priceless stuff.